I now want to introduce our presiding judge for 2015. I say this with a little bit of a bittersweet sentiment because in practicing civil myself, it means we're not going to have Judge Austin for the following year on civil. He's going to be in the administrative role. Judge Austin has really distinguished himself as one of the finest judges in our county. His judicial demeanor is talked about as being one of professionalism, frankness, candor, and also, of course, his good humor. I've seen him deal with difficult pro pers, with aplomb. Judge Austin, it's always a pleasure to appear in his department, and that would be missed in 2015. But we're confident that he's going to do a wonderful job as presiding judge. I also want to mention that Judge Austin this week just received his second Alameda Contra Costa Trial Lawyers Association Judge of the Year. So, Judge Austin.
I've been asked to talk about the state of the court in 4 minutes or less. For the last several years, this would be kind of a downer speech where we would talk about the unrelenting budget cuts, the things that have reduced our staffing down to 2/3 of where we were 6 years ago, and just general doom and gloom. You've all heard it. We're shutting down this, we're reducing hours there, we're laying off, furloughing, downsizing, cutting, crimping, squeezing. When I give that talk, I usually don't feel like a judge. I feel like a contestant on The Biggest Loser. So I'm not going to do that. And that's because I genuinely see that we may be coming out of things. We may have hit bottom, and we're ready to turn the corner to reinvent our court, redesign it in ways that will expand services to you and to the public for years to come. I think if you look at the state level, at least this year with the governor's proposed budget that just came out, we're not going to see any real cuts for the first time in many, many years. Instead, I think there is even a possibility we're going to get a little extra and start to come up from the hole that we're in. It's going to take a long time to rebuild what has been taken down, but at least it's a step in the right direction, and it's given me a good feeling about where we're headed. I think another big thing that's happened at the state level is we've hired a new administrative director of the courts, Martin Latino, who comes from the governor's office as part of his cabinet. He has a close relationship with the governor, and that can only help. There's been kind of a different way, a different strategy of seeing if we can get some additional funding to rebuild the courts, and I'm hopeful that those relationships are going to be of assistance to us as we go on. At the local level, our new CEO, Stephen Nash, has brought really a renewed focus and energy on saying, hey, this is what we got, let's do the best we can with what we have. And how can we redesign and relook at things to give better services? We're starting with an emphasis on technology. But the first thing one of the first things he did was he stole away the best IT professional in the state from Sacramento's court, who's head of Pettit, who some of you may have met. She's just wonderful, hit the ground running. She's expanding services everywhere, relooking at all the things that we're doing, including our computer systems internally, phone systems, in all aspects of IT. Through our work, we're set to begin testing an expansion of e-filing somewhere near probably late spring, early summer, with the hopes of maybe expanding into e-filing by the end of the year or next year in much broader areas. So that's exciting. By redesigning the way that we work, we've also reduced some of the backlogs that we've been plagued with over recent years, because we don't have anybody working in the clerk's office, or we have a few people still, but not enough to do a lot of the work that has to be done every day. We've significantly reduced the wait times in our clerk's offices through a lot of different kind of strategies, and started a Q-matic system. Some of you may have seen the little ticket pullers, and the computer system goes up, so it makes the wait that you have a little more bearable. We've also reduced backlogs in all kind of filings and papers. We used to have stacks and stacks of files that we would measure by the foot, and those have gone down to still, it's not a good level, but it's so much better than it was when you walk in the clerk office just a short time ago. By the end of the year, we're doing little things also, starting like talk to a real person on the telephone programs. Which, for all of those who have been lost in our phone tree, you might appreciate that. Really already implemented it in traffic, so if somebody calls in, they can get right through and talk to somebody. And we're trying to figure out ways to do it in other areas of the court. It's just so hard because we don't have a real person to talk to somebody on the phone. Everybody's at the window and doing all the other work. But we're trying to find ways within what we're doing, changing our work processes, to see if we can do those kind of things to better serve the public. So, despite all the problems, there's a lot of good energy and excitement with our court these days. I know, and I even feel that as myself up here, I sound a little like Annie singing, there's got to be a morning after. But I really genuinely believe that we've turned the corner, and you'll be seeing real differences. It's not going to be something that happens overnight. It's going to take years to rebuild what took years to take down. But I think we're well on our way. And we wouldn't have made it without all of your assistance. Laura's help during these dark times has been a point of light, and I'm sure with your help, we're going to be able to pull ourselves back up again in the years to come. So thanks.
That was my opportunity to introduce our keynote speaker. Our speaker today is Honorable Justice Ruvolo, and we can truly boast him as one of our own. Before he got involved with Contra Costa, he started off like my dad as a Jersey boy, going to Rutgers University, and then came out to the West Coast and went to the University of San Diego Law School, where he was the editor-in-chief of his law review there. He started off as a trial attorney with the U.S. Department of Justice and stayed there for 5 years, and then moved on to the firm Bronson and McKinnon, where he was the managing partner of the Walnut Creek office. You want to talk about various people with meteoric rises. Justice Ruvolo absolutely fits this mold. Within less than 3 years, he was appointed to the Superior Court of Contra Costa in '94, and then in '96 was appointed to the First District Court of Appeal, Division 2. Since 2006, he has been the presiding judge of Division 4 of the First District Court of Appeal. He has been the trial judge of the year for the Alameda Contra Costa Trial Lawyers Association. He's been the appellate justice of the year from the San Francisco Trial Lawyers Association, and he was justice of the year from the Italian American Bar Association. So please welcome Justice Ruvolo.
Last time I was here, Larry Cook invited me. He was the incoming president, and I spoke about the Massey Cole case, Caperton versus Massey Cole. You remember that, Larry? And the Supreme Court, sure enough, struck down that decision. I won't go into the details of it today, but I've known Castro Meadows, Schwartz, and Cook for some time. I couldn't help but driving over here today to see an analogy between that firm and national politics. I mean, am I the only one in this room that has thought of them as kind of like Bush family of Congress? Well, it's good to be here with you today, Jeb, taking the reins. The other Jeb is in San Francisco today, I'm told. In any case, it's a pleasure to see so many of my friends here for many years, and thank Teresa Hurley for helping me get here today. I need to bend over and get my notes. In your materials for today, I've included a handout that the Commission on Judicial Performance provides that are facts about the Commission on Judicial Performance. I'm impressed by how comprehensive that document is, and I'm going to try not to dwell too heavily on the details of what the Commission does. I'll try to give you an overview of what the commission does and how we go about our work. But I commend that to you. Also, there's a flow chart that will show you the pathway that we follow procedurally from complaint to disposition, either closing or the imposition of discipline. And I welcome you to follow along with that as well. Okay, let's see if this clicker works. Oh yeah. All right. The Commission on Judicial Performance was first formed in the year 1960. Unsurprisingly, California was the first state to commission such a group, and it was a model for many other states in the years to come. In 1994, which does not seem that long ago, although it was the year that I was first appointed to the Superior Court, and the year that the third three-strike law became effective, there was a big debate in California about the work and makeup of the commission. At the time, the commission was overwhelmingly a majority of sitting and retired judges and had very few public members. And there were some high-profile cases that came about that led some critics of the commission to refer to it as the Commission on Judicial Protection. Those of you who were around back then will remember Prop 190, which radically changed the makeup of the commission, and it is now a commission that is comprised of one appellate judge, two Superior Court judges, and 8 non-judge members. There are 2 lawyers who are appointed by the governor. There are 2 public members appointed by the governor. There are 2 public members who are appointed by the Speaker of the Assembly, and 2 by the Senate. So that's our current makeup. And I have to say that having worked now, coming up to my 2nd anniversary on the commission, I worked with these folks for the last 2 years. I have been very impressed by their dedication, how deferential they are, how understanding they are to the work and the demands of the judicial office, how respectful they are of the discretionary aspects of the job, and the public members are always engaged in discussions and dialogue with the judge members in an attempt to understand better what we do, how we do it, and give better context to the complaints that we must deal with. The jurisdiction of the commission is over all judges in the state, and share jurisdiction over subordinate judicial officers with the presiding judges of each county. Without order, putting them in order, the 3, oh, there we go. Maybe I need to be closer to that. The purposes of the mandate of the commission are to maintain public confidence in the integrity of the judiciary, enforce standards of judicial conduct, and protect the public. The lead up to Proposition 190 included a task force that then Chief Justice Malcolm Lucas had established, and the purpose of that was to not only come up and satisfy the public demand for greater accountability of judges, but also to shore up what was considered to be, by this task force that issued this report, the waning respect for the judiciary in the eyes of the public. So that's why the mandate of the commission is not only to protect the public, but is to ensure and to shore up the integrity of the judiciary, so we continue to have public respect for all judges who are working so hard to accomplish what needs to be done. That's a cartoon that was in the Sacramento Bee during this period of time, and there was a lot of that going on back then. But enough of the history of this. Let me just turn to the work of the commission. We have multiple levels of discipline. We can do everything from close the case, which happens, as you will see in a few minutes, in 97% of the cases. The complaints are closed without discipline at various levels of the process. But the least severe level of discipline is an advisory letter. That's a private letter to the judge pointing out the problem in particular conduct that was reported and how to approve and avoid doing that again. A private admonishment is again private, but it's a little bit a higher level of discipline. And then we get into the three areas of public discipline: the public admonishment, the censure, and then finally removal. Now, the annual report of the Commission on Judicial Performance includes a synopsis of the discipline that is actually been handed out over the course of the preceding year. In the case of the private discipline, well, we do not obviously identify the judicial officers who were involved in that, and in fact, in our narrative description of what happened, we try to neutralize it in a way so that the facts don't stand out and the person is identified through the circumstances of that. We do this not only to be publicly accountable for what the Commission does during the course of the year, but also to help give information to judges as to what's going on, where the problem areas are, and how they might, by becoming aware of that, avoid any problem. Filing of the complaints, we find that litigants themselves or family members or friends who accompany them in court by far file the most number of complaints with the Commission. There are the rest of the percentages of the sources for the rest of our complaints. The 2% at the bottom, source other than complaint, includes articles, news reports, for example, that are unreported. And the Commission is required, if it becomes aware, through a reliable source, to at least take a look at that and do some preliminary investigation. So they do, from time to time, 2% of the cases, initiate a complaint inquiry based upon accounts of the news. Now compare the source of the complaint with the complaints that are closed with discipline. And you will see that even though the litigant family and friends were like in the 80% of numbers of complaints we received, it's substantially fewer. So it's only 45% of the discipline that we impose results from complaints originally filed by litigation, family, and friend. Noteworthy is the fact that although we only get 5% of complaints from lawyers, those complaints generate 18% of the discipline. So there's a higher correlation between the complaint and discipline in the case of lawyer reports than in the case of litigant reports. And the same is true in where we get to complaints from judges and court staff. While 18% of the discipline imposed results from the complaints of the court and staff, as we saw earlier, we only get 2% of the complaints from them. So we have 2% of the complaints from judges and court staff and 18% of discipline. So there's a higher correlation of discipline with reports from lawyers and court staff than there is from the public or other sources of complaints. The commission, although we have a staff to help us, we've got a staff of about 20 lawyers who do the investigation and due diligence, whatever we get in the processing, when we get complaints. The commission members, all 11 of us, take steps and vote on every complaint. We get about 1,200 complaints a year, and most of those are closed at some point along the workup. Many of them are closed in the very beginning, either because they are complaints about judicial error, plain judicial error, complaints about that are uncorroborated, complaints of temperament, that we get the transcript and it's pretty clear that there's nothing reportable there. But we still vote on every one that we're going to close if we choose to close them without an investigation. And as I mentioned, the vast majority of these complaints are closed without going any further. We call that our consent calendar. Of 1,100 of the complaints that we receive during the course of the year, the cases are closed initially in over 1,000. So we have only about 88 complaints every year, that at least last year, that went beyond the initial investigation. So we've got 90% of the cases of the complaints are closed without anything, any action being taken. Although they're all written up, but there's a memo we get on each one of those cases. They don't go any further. If we decide not to close a complaint, it's one of the 88 cases that we feel there is a reasonable probability or a prima facie case of misconduct, we will institute either a staff inquiry or a preliminary investigation. The staff inquiry, the only difference between these two levels is a staff inquiry can only result in an advisory letter. So if we see a complaint and it appears to us that even if it proves out to be true, it's not going to be likely to result in anything more than a simple advisory letter, we will start with a staff inquiry. However, if we have any inkling that a greater degree of discipline could come about from that complaint, if it proves to be true, then we will send it out for a preliminary investigation. In all cases, unless we decide to close it, the judge who is involved, the subject of that complaint, will be informed of the allegations and given an opportunity to respond. So if we decide that we're going to go ahead and start a staff inquiry or a preliminary investigation, the judge is contacted and is given an opportunity to respond. The letter that we send out, you have a copy of, I think, one of our preliminary investigation letters in the materials. That was in a public discipline case some years ago. But it gives you an idea of the level of specificity that we include, the Commission includes in its letters to judges advising them that an investigation has been opened, including what the facts are believed to be, the date and location of where it occurred, and if it involves a particular case, the specific case out of which the matter of the complaint arises, and the text of any alleged comments that are the subject of the complaint. After the the staff inquiry is completed, our options, as I mentioned, are to close the case, issue advisory letter, or then elevate the investigation to a preliminary investigation. If somehow we thought wrong and that the staff inquiry, we thought it would at most be an advisory letter, and through the investigation we're concerned that it could be a higher level of discipline, then we have to decide to elevate it to a preliminary investigation. After the preliminary investigation is complete, we can again close the case, issue an advisory letter. We can defer the investigation for a period of monitoring, which we sometimes do in the case of on-bench demeanor misconduct. We can give a notice of intended private or public admonishment, or we can initiate formal proceedings. What formal proceedings? We only initiate formal proceedings in about 2 to 3 cases a year. So even though it's the focus of a lot of what we do, because it can lead to the highest level of discipline, it's very rarely invoked. But in any case, in those very few cases where we decide that to initiate formal proceedings, there is a panel that is appointed by the Supreme Court of 3 special masters who will hear and take evidence, and of course they get the formal complaint. There's a formal complaint. There's an answer that the judge is given an opportunity to file, and it's very much like a mini trial. And at the conclusion of that, the special masters give to the commission a report of their findings, factual findings, and whether and what canons they feel have been implicated by that conduct. There's a post-hearing briefing that's made both to the masters and to the commission before we issue a proposed findings and disposition. Our options at that point, if we are going to go ahead and impose discipline, is we can still go back and ratchet down the discipline to public admonishment if we wish. But we also have the option of going for imposing a public censure and removal. As I mentioned, very few cases go to formal proceedings every year. Let's see. Okay. The types of misconduct that result in discipline in a period of about 8 or 9 years that's recorded in that slide. They're not in order, but by far, demeanor and decorum is the #1 issue that results in discipline imposed. On-bench abuse of authority is second, and then it's followed by failure to ensure rights, failure to disqualify or make disclosures that are required in certain cases, ex parte communications, the appearance of bias not directed towards a particular class, but towards a cause that's pending in front of the judge, and abuse of the contempt and sanction procedure. I know that procedure, the Judicial Council Education arm, takes a lot of time, and when they instruct judges as part of the educational process, they spend a lot of time on contempt and sanction proceedings, because there are a lot of due process safeguards that are built into that for the targets of that contempt or sanction, and it's important that judges follow it. We even have scripts that help judges follow this appropriately. But nevertheless, if there is a shortfall in ensuring the rights of the target for the contempt or sanctions, that can and does lead to discipline. Let's see. That's just the numbers of how many people we have in our group under our jurisdiction. As I mentioned, we have investigations, complaints received. We had 1,209 complaints in 2013, and subordinate judicial officers, there were 126 complaints. And of the 1,200 complaints, it involved about 900 different judges. So we had a couple, two complaint judges in the course of that year. Now, the reason that the number of new complaints doesn't comport with the total case dispositions is these are moving targets. So you don't have everything that's filed in 2013 was adjudicated in 2013. We had some from 2012, and so that's why these numbers don't quite add up. But the fact remains that the dispositions, regardless of the number of new complaints that were filed that year, the dispositions were 1,181, and we closed 1,061 in the beginning. And then we investigated and then closed 88 more of them. And the reason that there are a fair number of these complaints that are investigated and then closed is it's sometimes impossible to know at the time we decide on a preliminary investigation what we're going to find. One of the problems that we're having now, this is a consequence of the budget shortfall, is a lot of proceedings are not reported as they were before. It used to be that we had, the first thing we would do if it was an on-the-bench demeanor problem, we'd get the transcript. And, most of the cases, it exonerates the bench officer, and we close it and move on. But now, the problem is that we may have no transcript, and then the investigators have to go to the people who were actually in court that day and have follow-up with the complainants. So, so there is, we do have a fair number, or a significant number, of cases that are closed after staff or preliminary investigation, and after we get more information about what's going on, and then we close it. And as I said, we imposed discipline in 30 of the 1,200 or 1,100 complaints that we received, which is about 3%. Okay, now those of you who are still awake, we're going to have class participation. Okay. What area of law do you think we get most complaints for? We got family. All right? We got a lot of family. Anybody else want to take a guess? Some criminal, I heard some mumblings of criminal. Okay. Family would be a good guess. It really would. But as it turns out, by far, criminal proceedings generate. Now remember, a lot of these complaints come from the litigants and their family and friends. So knowing that, it's in retrospect not terribly surprising that we get a high number of complaints from participants in the criminal justice system. What I think may be of more surprise is that we have higher percentage coming from general civil than from family law. But those are the facts, those are the statistics, and I also have talked to people and they said, oh, traffic, got to be traffic. Nobody leaves traffic court with a fine. They're not going to put in a And we do get a lot of those, we do. But it's relatively few in percentage, which may surprise you. So I'm glad we had a chance to do that. Let's see. Okay, and then the imposition of discipline pretty much follows along the same lines of the source of complaints. There's no outliers there, although we do get a fair number of discipline coming out of off-the-bench conduct. Off-the-bench conduct includes DUIs, judges participating in going out to the county fair, big state, dunk the judge, throw the baseball into the judge and down into the water, those kinds of things, and using titles inappropriately. So, I don't think we've had any in our county fair for quite a long time, but we're a big county, we're a big state. There are a lot of little counties. So, this is the website address for the Commission on Judicial Performance. We've just updated it. It includes our annual reports and has summaries, as I mentioned earlier, of past disciplines. There is a database that's searchable by judge through the state. There's also searchable by type of discipline, as I delineated that. It's got a lot of the history of the Commission, the statutes, and constitutional provisions that govern what we do is also included in on the website, and the rules that we follow are posted on the website. And I think the fact sheet that you also have in front of you is also part of that. With that, I want to say in closing, before I take any questions, that by far, if these numbers impress you at all, it will impress you with the fact that the overwhelming majority of judges are doing a terrific job in this state. You have a right, you judges have a right to be proud of yourselves, and we as members of the legal community have a right to be proud of you as well. This process, as I said earlier, it was birthed from a need not only to protect the public, but to maintain the integrity of the judiciary and retain public confidence and respect for the office, which all of you have some equity interest in, and I think it achieves that. With that, I want to thank you for your attention. I hope this was interesting to you, and I'm happy to take any questions that you may have. Except for Tom Madden.
Okay, I got a question.
No.
Back there.
Okay. Yeah.
Yeah, there's been some unfortunate reports about sexual conduct on the bench recently, and I'm wondering, well, many things, but mainly, do they fall under a particular category, or do they have their own category? Is that happening more?
Last year we had, anecdotally, it seemed like we had more than they had in past years. I don't see it as epidemic. I just see it as kind of a glitch on the radar. But we did have several cases, and that's all I can say about that.
You know, there's demeanor or protecting the public, or
Say that again?
you listed many categories of type. Would that be under demeanor or protecting the public?
It would be under that or abuse of authority as well. Where the judge is overstepping bounds with staff, that would also come under abuse of authority. Sure. Anybody else? Yes.
The judges that avoid the discipline by retiring, I think
Yes, there were a few, yes.
Are they still able to be given temporary appointments to sit on the bench after?
Normally not. As part of the disposition of a particular case, we will normally insist, if the judge, see, the fact that a judge retires doesn't necessarily mean that they cannot be disciplined for prior conduct while on the bench. They still can. They're under our jurisdiction as long as the conduct occurred while they were on the bench. So, if we are going to resolve a complaint where a judge is going to retire, normally it will include a provision that the judge will not seek further judicial office or participate in any quasi-judicial activities, but not always. I mean, that just depends on the case and circumstance. Yes?
So who does the investigation? I would assume that you have to have a neutral party to do that?
We have staff investigators who work directly for the commission who do that, and they're very good. I mean, they're bright, they're dedicated, they are thorough, they are objective. Their reports include not only summaries of the investigation and what they discovered and the facts and excerpts from transcripts or pleadings or whatever it happens to be, emails. You get a lot of email evidence now. But they also describe what rules are implicated, what canons are implicated, and why in this particular case. So there's a whole analytical section in that report that we get that's of great assistance to us as well. Yes, sir.
There have been a couple of reports in the popular media lately about under-sentencing of particularly sex offenders. Does your caseload include any complaints by victims or the press for too light sentencing by judges in the criminal area?
No, we don't act officially on that. We've heard some criticism about a couple cases, but I think that if you were there and participated in the entire investigation and considered all of the factors that we have to consider, that Rule 7.1 of our rules sets forth, just like the rules of court on sentencing for aggravating factors and mitigating factors, we have the same analog in our rules that set forth factors in aggravation and factors in mitigation. And so there's a real analysis that's done, a lot of give and take before we decide what level of discipline to impose. So, and it includes a lot of factors, but I'm pretty satisfied with where we're coming out on most cases. I don't agree with every one. And where we don't agree, the discipline will say, Judge so-and-so or so-and-so person would have done, taken a different approach. Do we have any more time? I have time for another question. Anybody else?
He's got one.
Okay, yes, sir.
What happened to Judge Zellerbach?
It was before my time. That was, since you have that in your hand, undoubtedly it was some public discipline. But I don't. It was before my time, so I don't recall it. I wanted to get an exemplar, though, to give you, all of you, an idea of the level of specificity that goes into these letters that we send out during the investigative process. It's not, a high-ball approach. We're very aware of the due process implications of what we do. Okay, Jeb?